Hello, everyone. Welcome back to HeirKare with Kathleen and Erik. We are estate planning attorneys providing services in Johnson City, Tennessee, and Suwanee, Georgia. We are here today to talk about trust funding. If you guys have been with us for a while, you know we've been walking through different documents. We recently did episodes on revocable trusts and irrevocable trusts. And so now we're going to talk about how do you get assets into your trust. So again, here we've got my handy dandy little demo for what a revocable trust is. Remember, this does not provide any liability protection. The soapbox I will die on reminding people. And we're going to talk about how do you get your assets in there, right? How do you get your house into the trust? How do you get your personal property into the trust? If you've got retirement sources, how do you get those pointed to your trust? Because remember, if it's not in here or pointed to here, your trust is not relevant to that particular asset. So why is this important? Why does trust funding matter? Well, like I just mentioned, if things are not in our trust or pointed to our trust, then we have a useless piece of paper. And you say, well, who would do that? Who would have a trust and then not use it? Well, this is super, super common. We see it very frequently. I will say, I think attorneys over the past decade or so have been getting better about encouraging their clients to fund their trusts, but we still have a ways to go. Thus, this episode and topic today. So, just a little story I want to tell you guys from earlier on in my practice when I was working up in Maryland, and we were working on some succession planning for a business. The business had lots of equipment. Total value of the business at the time was probably around $10 million. This was maybe 2010. So it was a good size, healthy, family run business. And they came in, we said, well, do you have estate planning? And they're like, we do. And they brought in, I'm not kidding, I think it was 3 binders this thick, full of paper,
Brought in a steak
a
dinner
steak
binder.
dinner binder, but 3 of them, right? So this was like
Oh
the
gosh.
filet mignon, surf and turf, super fancy steak dinner one, right? And
Uh,
um, and so I'm going through there. I was like, oh, I see you have a SLAT. I see you have a irrevocable life insurance trust, an ILIT. And so can you tell me which policies you have in there in these trusts? And they said, well, we don't have anything in the trust. And I said, okay, so what did the attorney who did this before tell you about funding? And like, oh, I don't know, I don't remember, you guys. And they had paid, and this was, probably at this point, early 2000s when they'd had it done. I think they had paid a total of about $10,000 that long ago for that planning. And what they
for
had
a big old paperweight.
was a paperweight or really expensive kindling because literally had zero impact because nothing was in the trust, any of the trusts that were created, nothing was pointed to the trusts. And on top of that, a lot of their assets were in their business, which was incorporated, and their corporation had no succession planning. So this was just a disaster waiting to happen. Now, fortunately, they came to us, we straightened it out. It was okay. Nobody died in the interim. But again, had someone passed away during that point in time, particularly with where things were with estate tax and state tax, actually, in Maryland at the time, it would have been, let's say, financially uh, much more painful as far as taxes go.
Would have been very tax
Very
inefficient.
tax inefficient. That's a nice way to put it, Erik. So Erik, why don't you start by telling us how we get assets into our trust and how we fund different assets?
Yeah, so there's kind of two buckets of assets here. We've got ones that have a title, like an actual piece of paper that says this is who owns this thing. And then we have ones that are what we call untitled assets. And so for titled assets, we're going to go and on that title, we're going to change that over. So for your house, this is going to be going and doing what we call a quit claim deed, and transferring ownership from your individual name into the name of your trust. Um, For cars, if we do decide to move your vehicles into being owned by your trust, we're gonna go and actually change the titling at the county clerk's office or at the DMV or wherever it is that your state uses for car titles. We're gonna go and change that over so it's owned by the trust. One little asterisk there is check with your insurance company before you do that. Because some insurance companies take the view that because it's owned by a trust, they have no idea who's allowed to use the vehicle because you can change that because it's revocable and it's amendable. And so they just insure against that by charging you a ton of money for your policy. So check on that. It may not be the best way to do it, but if we are going to move it over, we actually go and change the titling on the vehicle. Same thing with boats, camper trailers, trailers that might be owned by a sole proprietor business are going to get moved over in that way. Anything that's got a paper title that you've stuck in your safe, we're going to go and change that titling. For bank accounts and things, we're going to go into your bank and we're going to talk to the teller and then probably the bank manager and then probably somebody in legal before we get an answer. But we're going to go and get the bank accounts retitled into being covered by your trust. The asterisk there is just sometimes that requires you to do a whole lot of changes with your auto pays and things, which gets a little messy. So sometimes we have to come up with work a solution for how to maybe do that to get most of the money moved into the trust, but in a way that's really not going to make a ton of work for you having to move things around. And there's a lot of different options there. So whenever you're working with your attorney, you should be kind of asking those questions. Hey, how much of this should I be moving? How much can I leave out? That kind of thing. And that'll be very state specific because different states have different rules about how much money we can move without a probate. Because Tennessee allows you to move up to $15,000. The bank can just pay that out to the person named under your will without having to open probate. So we know, okay, we need to be under 15. Different states have different laws. You need to work with your planners on exactly what that threshold is for you. But there's often a way to work it so that you can manage it, get it all moved into the trust as much as possible, but still have a manageable amount without having to do a whole bunch of work changing over all the different credit cards, utilities, all those things that are coming direct pay out of your account. Um, so that's kind of our titled assets. So, and then Kathleen, why don't you talk with us a little bit about how we move things that we're either not changing the title on now or that don't have a title? What do we do with those things?
Yeah, so a lot of times, a lot of your estate is personal property that you don't have a piece of paper for that says you're the owner. That could be your grandfather clock, it could be your couch, it could be your fancy piano, it could be your pots, your pans, your clothing, right? All of that is personal property. And so different lawyers will approach this differently. Eric and I, we say, hey, let's go ahead and do an assignment of assets and say everything that you own right now that's personal property and everything that, excuse me, you own in the future that's personal property, you are now assigning to your trust. And so that is just a piece of paper that's signed and notarized that goes along with your trust documents to verify that that is part of the assets. Um, there's other types of assets that sometimes we don't move immediately or we can't move. Eric talked a little bit about this, but just to hit on retirement accounts specifically, um, and this is not the same as with a traditional taxable brokerage account, but an IRA, a 401k, a 403b, a TSP, the alphabet soup that constitutes our different retirement options. Those we are not going to put into your irrevocable trust because those are very specific financial instruments governed by federal law, and we can't just retitle that. And so what we do is we add a beneficiary designation on there. Now, if you're married, it might be that you say everything to my spouse, and then the contingent is to your trust. In some situations, we make it just go to the trust from the get-go. And again, how you're doing that, why you're doing that will depend on uh, the different facts and your goals for your personal plan. So that's how we handle those assets that we aren't necessarily moving into the trust right now. We did want to take a couple minutes also to talk about the assets that we don't love working with, or assets
They give us a really
they
hard
give us a
time
really
dealing
hard
with these ones.
time, they add some complications, or they're just super hard to deal with. So I will start off with the first one. Um, And I will say, I'm not going to talk in detail about this right now, but this also comes into play if you're doing long term care planning. This is a very difficult asset to deal with, and that is the timeshare, right? Timeshares can be essentially points, it can be a deeded interest in a resort somewhere. But all of them are managed differently. They have different rules about how to transfer those interests. They make it, generally speaking, hard and expensive to transfer those interests. And so those are just going to add a level of complexity in getting those addressed. And the reality is, most likely, you're going to get the use and benefit out of it during your life. And after that, there's a really good chance that people are just not going to want to touch it. They're going to say, not it. And it will eventually just revert back to that managing company. So that's timeshares. And the reason briefly long term care looks at these things, or I should say, if you're doing long term care planning with an intent to go on to Medicaid, is that is considered a countable resource. And so we'll have another video where we talk more about long-term
It's
care
hard,
planning.
hard, hard, and expensive to
Yes,
transfer
and they're not fun.
and sell.
Yes, I would say the bigger issue is in the long-term care planning because we can't just ignore it like sometimes people choose to do in an estate planning context.
Yeah.
So that's one of my personal assets that I find a little more difficult to address. Eric, what about you?
Yeah, so one that's a personal one of mine is any stuff that's held through a program called CompuShare. They while they make it super easy to buy shares of stock in whatever publicly traded company you want to buy, they've got great programs that'll automatically sell things for you as soon as they gain a little bit, and so they kind of gradually play that game of like every penny we go up a little bit. Um, Transferring them through an estate or a trust or anything like that is horrifically difficult. The amount of paperwork that they make you jump through. Um, I've kind of worst case one for me was at a state where they were up in a more rural part of the area of Tennessee, and they have one bank in town, and that bank had one person who came around once every 2 months who could provide the stamp we needed on her signature for her to be able to get it transferred. And so it ended up dragging out the estate an extra 2 months longer than it needed to, because of course when she got around to doing it, she showed up the day after the person was there, right? So it was another 60 days before we could do anything. And I had the court breathing down my neck, hey, why can't we close this thing? I'm like, we literally are just waiting for somebody to show up at this bank to do this. Um,
Well, and on a personal
so that's one
note,
I really don't
we
like.
had my husband and I had some DRIPs, which is direct reinvestment plan, basically where you get dividends and they automatically reinvest it into that same stock for you. And it was a nightmare to deal with them as the account holders ourselves, much less trying to go through an estate. And I found them to be the tax documentation and stuff for when you sell those things gets a little more complex.
Yeah.
And so if you're up for that work, I mean, I applaud you. But if you are into simplifying your life, I would just move away from that until a more accessible
Yeah.
investment option. Anyways, go ahead, Eric. I had to.
Yeah. And there are a lot of them. Vanguard, Fidelity, E-Trade, all of those offer the same services with a much more user-friendly
Yes.
interface. Um, but another one that's just as difficult and that you just have to be very, very careful with is when you're dealing with any kind of crypto investments. They are number one, just from an administration point of view, you need to make sure that people have access to the path login info and stuff to be able to get to your Bitcoin or whatever, Doge, whatever wallet. Um, but the and obviously the bigger, crypto exchanges and stuff probably have systems in place for your estate to be able to claim it. But it is just something that you need to be aware of, that it goes along with the other passwords and things to your things online to be able to get access to. And then when it comes to planning out how to best pass those along, um, it is very, very specific, the best way to do that. It's very tax driven. And it really kind of depends on the specifics of your situation and what crypto's doing in the moment when you're doing the planning. And so it's just really, really important to consult with an estate planner, but also an estate planner who's comfortable dealing with those more complex tax issues. Because not all planners are. There are planners who focus in different areas, and we're lucky at our firm to have kind of two of us working together, so we can kind of cover the whole field. But I honestly can say, like before we were working together, there were certain areas where I just kind of said, that's an area of estate planning that I'm not comfortable working in. You're going to need to go talk to somebody else. And so you just need to make sure you're talking to the right people about how to plan for that. Um, so that's kind of crypto. I know Kathleen, you've worked a good bit with royalties and books and
Yes.
things like that. So why don't you tell us about your experience with that? Because that's an area I haven't really dealt in.
Yes. So
So
I've had several situations where we have royalties or ownership of books. Sometimes the royalties are inherited rights. Sometimes people have written books themselves. Obviously, this could apply to music and other things as well. Again, this is going to be very specific to your situation. So if you are getting royalties, the company managing those royalties will often have forms that you can fill out and provides documentation, and then they will update who those payments go to. Some of them are pretty well set up for that. Some of them are not. And so, for example, I think it's Kindle Direct Publishing, Kindle KDP, they've got some information about doing things through probate. But if you do want to do trust planning, you're going to have to make some decisions on what your priorities are, right? And how you want to manage that particular asset. And you got to talk to your attorney about how to do that. Speaking of royalties, right? So sometimes you can also assign your interest in different types of assets. One thing that we didn't talk about beforehand, Eric, but just came to mind that is similar to royalties are mineral rights. So we don't have a lot of that in Tennessee. I've seen a little bit. Lots of times people in Tennessee have inherited mineral rights from other states. And I would suggest that because the mineral rights have been around for a long time, they actually generally have a pretty good procedure in place. It is my experience that it just tends to be very slow moving. So if you want to update ownership or anything like that, it's something you absolutely can do, but it's not going to be like walking into your bank, bada bing, bada boom, you're done, right? You're going to go back and forward. You're going to wait a while. And yeah, so I think, Eric, if you want to add anything else about other categories for funding or things to think about, please feel free. But I think we're going to end on a story of warning about what not to do
yes.
when you are funding your trust. So, story time with Eric. Go for it.
Yeah. So one area of our practice is that we work with people who now live here. People often move to another state to retire, and so they've come into Tennessee with a fully carried out plan. And honestly, a lot of times when they move here, they're fully funded. That's like Kathleen mentioned earlier. It's over the last 10 years, especially, attorneys have been getting a whole lot better about making sure that we get things funded into our trusts, that we're instructing our clients on how to do that well, and all of that. So one area that we do work with though is after mom or dad who did the planning has passed away, working with the family on carrying out that trust. And it's just an area where a lot of people aren't familiar with. They honestly, a lot of the time it's a lot quick pat on the back. Yeah, you're doing a great job. Keep going. But we do work with those. So I had one come in probably about 2 years ago that was mom had done pretty well for herself, had several $1 million in the bank, and then had her house. Okay. All of the bank accounts, all the retirement accounts were done correctly. They were retitled, and her house in Maryland had been titled correctly. Well, when she decided to move to Tennessee, she was going to move in to a house that she was going to buy with, and her daughters were going to move into the house with her. Or, well, one of them was, and the other one lives down the street. Um, so her plan was that she wanted to make it so that the daughter who was moving in would get the house. And rather than coming to an attorney and saying, hey, here's what I want to do, how should I do this? She just, when she bought the house, said, hey, let's just put it in all of our names. And she meant to do it, I think, with what we call rights of survivorship, so that would basically automatically transfer the titling to the daughters. But even then, it still would have been the two daughters, not just the one like she wanted. But she just told the closing company, hey, I want my daughter's name on the deed and I want them to get it when I die. Well, they didn't do that. They titled it in what we call tenants in common, which means that mom's 1/3 interest in the house went past under, and so we had to probate her will. Luckily, we do have a process here in Tennessee that lets us do that pretty quickly when there's only real estate, but we had to go through that extra process. And then that 1/3 value of this close to $1 million house had to be the one sister who was supposed to get the house outright under mom's actual intent had to buy out all of the cousins and nieces and nephews and everybody else out of the trust to actually get titling into her name. And then the sister who wasn't supposed to be on the title at all has had to, over the last couple of years, and we're still in the process of doing this, had to slowly gift chunks of money back to the sister who ended up with the house, just to undo this thing. That if mom had just come in and said, hey, we can just add a thing into my trust that says when I die my house goes to my daughter, all we would have had to do was about a half a page trust amendment, still leave the house in the trust, and we would have avoided all of that extra stuff. So that goes to say, like, trust funding is a great to do on the front end, but it is an ongoing thing that you have to pay attention to, and trying to do it yourself without talking to the lawyer can be very, very detrimental to your family. In that situation, we ended up with what would have been a $200 amendment, cost the family almost 10 grand to get it all fixed and sorted out. So it just kind of goes to the importance of, along the way with your funding, making sure that you're checking in with your lawyer, making sure that you're, even if it's just a quick email, hey, I'm good, I'm doing this thing, I think I'm doing it right, and the lawyer may reply back, yeah, that's fine. Or I've got one actually just this week that she emailed me and said, hey, I'm buying a new house, I'm selling the one that's in there. I took a quick look at the trust. Turns out that house had a very specific gift of where that house was going. So I shot an email back, said, hey, it's gifting to the specific person. Do you want the new one you're buying to also go to that person? She does. All we need to do is a quick amendment to the trust to just change out the property address that's listed as in that gift, and we're all set, good to go. And if she didn't contact me, we may have ended up in a situation, 40 years from now, where the property that she had perfectly planned for ends up not ending up where she wanted it to go, just because she didn't touch base with her lawyer and spend little bit of money to get it fixed, and it would have been a lot of money to handle it on the back end. So cautionary tale: do your funding on the front end, and then touch base with your lawyer anytime you're making any kind of major change to an asset in your portfolio.
Well, thank you, Eric, for going through that stuff with us. And everybody, please remember that we are here to provide you guys with information and not advice. Stay tuned next week. We are going to go over some basics of long-term care Medicaid planning. Until then.